That's why I asked Mr. Rakesh Anand this join the real word that you do. Otherwise, my friends on the dais and off the dais will probably feel there's something else. I'm not a lawyer, but there's something else attached to it. So better be careful when we use our words. The topic is the need of the hour, according to me. We have seen the development of international law. It goes right back to WTO. Circumstances have changed. India has done its bit. If we look back to the history of this country, we find we were up with WTO disputes and complainant and respondent in, I think, the maximum matters in 79, 80. A situation came when WTO became irrelevant. A stage that came also. But today, there is a fact that we have to all accept, and that is that India is an economic power. What we need to do is the discussion that we need to look at. How do we make capacity building? And that too in legal practitioners, or legal profession, of Global South for commercial dispute resolution. In fact, after long delay, we brought Commercial Courts Act in 2015. Fortunately, we amended it. And now things are more or less in place. But our experience in the last 2 years in the international front has not been very happy. Whether it was treaty arbitration or whether it was commercial arbitration, we were not successful, despite the fact that India had foolproof cases. The reason is this, that's one of the reasons that we need to build capacity all over, not only in India. I fortunately have with my co-panelists from Brazil. I remember when I went there, when the BRICS Legal Forum was doing it, and we thought BRICS countries must at least develop a law first, where we exchange our young lawyers. We need to look at each other and then point out back into our countries what are the loopholes in our law. We must develop norms by which at least the BRICS countries' judgments passed or awards given are directly executable. I'm not making any adverse situation, but I know of a fact that an award made in India, when it came for execution against a Chinese company, they said, we have no assets in this country. And when we went back to China to do it, they said, we need to start the process once again. Now, if this is the situation across us, we need to amend ourselves. We need to bring those laws. We need to exchange our people as to what we should do. Singapore Convention was one thing that we thought we will be able to achieve by at least going to mediation, which mediation under the Singapore Convention becomes akin to a decree. But we have not been able to ratify that so far. Many of us have not been able to do it. Now, there could be some political reasons for it, there could be some other reasons for it. But what a lawyer has to play a role is the question that we are debating upon. I think let me start from my law schools. My experience shows some of the law schools, Amity, OP Jindal, have a special subject called international law for a child to pick it up and learn it. That's the beginning, which we have done. I'm sure other universities and law colleges will adopt it also. And they will also go into the same direction in giving them an expertise of what international law is, especially in commercial disputes. while speaking somewhere on Commercial Codes Act, somebody had put a question to me from the audience to say, what the India is achieving by making Section 12A added to the Commercial Codes Act? And I said, till parties take a stand in court, a mediation has become a compulsory there. So that people who are not even talking to each other after a dispute arose in commercial matters, they will maybe sit across the table with the mediator. And many times it has happened that you've seen miracles happening there. Because both sides are commercial. They are not looking at long-drawn battle in arbitration or even in the court. So when the mediator has a caucus session, you'll know what exactly the underlying interest of a particular party is. And that was the purpose why 12A was added. We need to also look at a need that we must provide, especially with respect to Global South. If any disputes arises between the countries, should we not first sit down to mediate? It may save us time, it may save costs, it may save many things. But the legal profession of the Global South will have to rise to the occasion to understand the principles of mediation, not otherwise. International disputes, cross-border disputes, the mediation principles are slightly different than what we do in domestic matters. And I'm sure those of you who are my foreign delegates here, I wish to bring to your notice that we brought an amendment into our Civil Procedure Code. And actually speaking, mediation picked up. Mediation is a very old situation in India. If anyone goes to Allahabad, you'll see in the museum a mediation settlement signed and written by Tulsidas ji himself, in his own hand. So mediation was not something new to us, but probably when British came, we gave it a go-by and we brought it back when we amended the Code of Civil Procedure. Ever since from 2006, if you see the journey of mediation, commercial disputes, to the last statistics I have been resolved over 53%. So 53% have not gone to court. They have not spent their time there. And instead, they have come back as partners as they were doing earlier and have gone through. Because ultimately, when you resolve a commercial dispute, it's actually affecting the economy of the respective country. So the bar has to rise to the occasion, and somebody asked me yesterday, so when is the next episode of arbitration? Bar Association has a wing of Madhyam which looks at mediation and arbitration. We had a founder, Sadhana Ramachandra, in her name, we had lost her, and we started doing episodes every 2-3 months, where we are looking at how international arbitration or arbitrations, disputes that are arising in interpretation of the arbitration can be solved to the youngsters. So capacity building is the need of the hour. And I'm only requesting to all my delegates that here, we must press our countries to come to a conclusion. New York Convention was made long ago. There are 174 countries to it. But can you see that? Read the provisions of Arbitration Act 1996. I have to still go to court to ask that whether my award should be implemented or not. Why should it not be automatic? Unless there is something else to it. If a decree of a court can be executed, then so should be an international arbitration agreement, award. But no, we still need that after 45, 46, 47, we go again those principles which are almost akin to Section 34 have to be done. And I think this forum would also note that we need to amend that too. Unless we find something so grave, so patently illegal, that you will not be able to recognize it. Therefore, there is a need for the bar to get up. Bar's capacity is important. And I think they well said catch them young, and young would be from the law schools. And that's why I feel what MIT and what probably OP Jindal and one or two more schools, law schools are doing, we need to do that. The second question comes that with all humility at my command, I feel law schools have mushrooming in the country. Many of them, without naming it, Mr. Yakesh Anand, I'm just taking his name, called me up to say, I have given a consent, so the convocation, you will go there. I said, all right. I just went to Hyderabad to do a matter, and matter got adjourned. And my cousin was not well, so I wanted to see her. And while I was going, I saw that big board of that university, which only had 4 rooms, the rest was everything in tents. And I called Mr. Yakesh from there. You think convocation at such a law school or a university would you wish to come? So I need to make infrastructure changes. I need to make the students comfortable. And there's a need for us that student from one university of India goes to another university across the global south and learn. This itself would make a difference in our learning process. This itself will combine us to do something together to meet the challenges today. And with the economies going on, cross-border disputes are manifold. In fact, I find disputes are today arising when you are actually entering into a joint venture or some clause or something else. That also needs to be addressed. Only it is possible to do so if we are able to get to know everything that we are doing. Our lawyers must accept the fact that learning never stops. I think I'm taught every day when I'm briefed. I learn every day from them. Learning should never stop. And if that's the motto, then we'll never be able to stop to learn how to, with the changing economy of the world, how do we change these situations? A question arose the other day. The Honorable Judge, I was sitting in the court. The Honorable Judge said, what is your prima facie view? I said, the prima facie view has to be that by an order of the court, this international situation has changed. Therefore, jurisdictions have changed. Consequently, everything will have to be now looked at from a domestic point of view. Please see, an arbitration hub is today or in Singapore, London, Paris. Why are we in global south not creating our own hubs? Why are we going and rushing there? I remember long time ago, I was early in my profession, I had asked the government, PSU, then why are you saying this? Why? See your arbitration. And you say it's interesting to see it was an English company doing petroleum extraction in the Indian Ocean. And the agreement said it will be governed by Indian law. The arbitration said it will be governed by English Arbitration Act. Place shall be Malaysia. So people started running between London and Malaysia, which will have the jurisdiction. So we need to look at, because if we are conversant with the fact that what should we put in our agreements is also important, especially when they're cross-border. How do we express explicitly what is the intent of the parties? And see how do we not raise questions in the arbitration agreement itself. How it can be done when the bar will have to start. Each bar will have to do that, whether it's an Indian bar or everywhere in global south, to start learning the international norms now today. We just saw in the last session, sovereign debt. We in India, in the insolvency, has brought it down. But the Supreme Court said go up. So we're again back to square one. These are issues that we need to debate, and there can't be a better forum than what Bar Association of India has done today. All that we learn from these sessions should actually be put to practice. We all must go back, tell our respective authorities, law schools, bar associations to please look at this and adopt something. With the economy going everywhere, and please look at this now. We started investment into this country. How will the investment be done if the investment we said, I will give you an option to go out of the shareholder, provided at that option I charge you interest at rate of 18%. This was not totally illegal because we can't determine the value of a share after 10 years. Therefore, it is necessary that these fundamental norms that we need to adopt in capacity building must be done. And especially in its two-tier cities of India, there is hardly anything with respect to international law, international arbitration or otherwise. Therefore, we need to look at how we start to build the capacity, not only in the law schools, but also to our young lawyers. We explain to them and tell them. And not only that, we refresh ourselves. What are the norms? As I said, from WTO, where we have come today. Therefore, today, all this global south needs to make at least 3 resolutions. Number 1, that arbitrations, cross-border disputes shall be recognized and shall be executable straight away. 2, unless that award is contrary to the local law of that country, execution will take place. And 3, that the courts will also lend their support to ensure that awards are not remain on paper. I can only give you an example of blending between bench and bar. A clear example is Delhi High Court. Bar and bench have, if I can use that expression loosely, have actually colluded with each other. And see the infrastructure that we created. We have arbitration center, where there is time has to be taken. I have to block my dates to get a space there to do arbitration. I have a mediation center where I have 80 cases a day with 250 mediators, many of them who are doing pro bono. Now, these are situations that are happening, and these structures have come up only because the bar and the bench thought we need to look at together. So taking this only an example to say internationally, especially Global South, we all need to cooperate with each other. We all need to make something together, norms together, maybe fundamental, and see how do we enforce them in the next coming times. Times are changing. In fact, I see economics changing so fast every day that probably there's a need to make our amendments to law very early. Even the only law probably I've seen so much of amendment is insolvency. I had never seen a code being amended so many times by the legislature. And apart from that, of course, the regulator is doing so. But arbitration has been amended 2-3 times after 2015. But we need to look at arbitration, especially in the cross-border. We need to look at those Chapter 2 of our Arbitration Act to see how do we amend it to bring those norms into that. Time, I know, is running short. We're already late. I do not stand between me and my all other friends. I have many other things to say. And when there's the jurisdictions, we learn from them too and have a great day. Thank you.